Supreme Court of India Naeem vs. State of Uttar Pradesh decided on March 5, 2024 INSC 169 facts of the case. The deceased had alleged that she had been set ablaze by the accused/appellants who had been pressuring her into entering the profession of immoral trafficking and prostitution. FIR was registered for the offence punishable under Section 307 of IPC, Prosecution Witness 5. The then Naeem Tahsildar, between the hours of 8:48 p.m. and 9:15 p.m., dying declaration of Shaheen Parveen, deceased, Exhibit K 6, came to be recorded by Prosecution Witness 5. Subsequently, she eventually succumbed to her injuries at 7:55 p.m. Consequently, the case crime number 1332 of 2016 was altered to the offence punishable under Section 302 of IPC. The trial court accordingly convicted them for offences punishable under Sections 302 and 34 of the IPC and sentenced them to undergo imprisonment for life along with fine. Findings of the court: undisputedly, in the present case, the conviction is based solely on the dying declaration, Exhibit K 6. A perusal of the dying declaration, Exhibit K 6, would reveal that before recording the dying declaration, Exhibit K 6, the victim was examined by Dr. A.K. Singh, Emergency Medical Officer at District Hospital, Moradabad on December 1, 2016 at 8:45 p.m., who has certified her to be fully conscious and fit to give the statement. After the dying declaration, Exhibit K 6, was recorded, a certification by Dr. A.K. Singh, Emergency Medical Officer at District Hospital, Moradabad is recorded once again to the effect that the deceased was fully conscious while giving the statement, Exhibit K 6. It can thus clearly be seen that the material placed on record would reveal that the deceased was in a fit state of mind at the time of making the statement and that it was not the result of tutoring, prompting, or imagination. We have no reason to interfere with the concurrent findings of fact that the dying declaration, Exhibit K 6, is true and free from any effort to induce the deceased to make a false statement. The dying declaration, Exhibit K 6, is coherent and consistent, and as such, there should be no legal impediment to make it the basis of conviction without there being any independent corroboration. We find that the dying declaration, Exhibit K 6, is cogent, trustworthy, and reliable to base the conviction on. The statement of the victim would therefore reveal that the motive attributed by the deceased is to accused number 1 Pappy alias Mashkor. She stated that she had a quarrel with her Devar Pappy alias Mashkor over partition of the house. It can further be seen that the role of pouring kerosene on the victim and setting her ablaze is also attributed to accused number 1 Pappy alias Mashkor. Insofar as other two accused, i.e. Naeema, wife of accused number 1 Pappy alias Mashkor, and her brother Naeem are concerned, the statement of the victim only states that they aided her Devar Pappy alias Mashkor. However, no specific role of how they assisted accused number 1 Pappy alias Mashkor could be found in the dying declaration, Exhibit K 6. We therefore find that, though the said dying declaration can be the sole basis of maintaining the conviction of accused number 1 Pappy alias Mashkor, in the absence of any specific role attributed to accused number 2 Naeema and accused number 3 Naeem, they are entitled to the benefit of doubt. Criminal appeal against appellant Naeem and Naeema are allowed, and criminal appeal against appellant Pappy alias Mashkor is dismissed.